We're going to go ahead and get started. My name is Robert McEwen. I'm a staff attorney at Nebraska Appleseed in our child welfare program. And for those of you that do not know, Nebraska Appleseed is a nonprofit, nonpartisan public interest law firm. And our core mission is to fight for justice and opportunity for all Nebraskans. And we do that by operating out of 4 core program areas. We have a child welfare program that I'm the staff attorney in. We have a healthcare program, an immigrants and communities program, and we also have an economic justice program. So we work on these 4 core issues in a systemic way. So what that looks like is, for the legal side, we do impact litigation and class action litigation. We also go to the State House. We do lobbying. We work with coalitions. We work with senators to improve the child welfare system in our other 4 areas, or other 3 areas through that means. And then we also get out into the community. So we do have people that are community organizers on staff to interact with our core constituencies. And those of you who are interested, there's a sign-up sheet in the back. In our child welfare program, we have something called the Legal Resource Center, and I'm hoping many of you are interested in working in the child welfare area because of the topics today. But we have, on our website, we have over 60 model pleadings, motions, petitions for practicing child welfare attorneys. We have a listserv that is limited to only people that are guardian ad litem or bio parent or foster parent or grandparent attorneys in child welfare. So basically anybody except county attorneys. We want to keep that confidential and have strategy discussions go on through the listserv. And then also we have a monthly newsletter that comes out with a legislative update and then also a case law update. So every appellate case that comes out in a month that is foster care related, we will summarize that. And then at various times throughout the year, we do free webinar CLEs over the lunch hour. So all of that is provided to anybody that's interested for free. So if you're interested, we have sign-up sheets in the back. And I think one will be passed around here in a little bit. But yeah. And if you do have any questions about that, for everybody that is watching at home or on the online, you can go ahead and contact me. I'll have my contact information on the last slide, and we can go ahead and get you signed up for our Legal Resource Center. So we're here today to talk about the Indian Child Welfare Act, and I'll give you a little bit of a roadmap of where we're going. We are here to talk about some of the changes to that LB 566 and the new BIA Guidelines make to the Indian Child Welfare Act. This is not an ICWA 101, so some of the basic things we're not going to cover today. It's going to be focused more on the new things. And we are going to start by talking about procedural changes to the Act and then move on to some of the substantive changes. And we're going to be talking about the BIA Guidelines and how they work with LB 566 the entire time. We're going to have a brief time for questions and answers at the end, but if anybody in person has questions throughout the presentation, please do not hesitate to throw your hands up and stop me. I want this to be fun and interactive as much as a CLE can be. And then we're also at the end, I'm going to have 2 of my friends here, Misty Thomas of the Santee Sioux Nation and Jill Holt from the Ponca tribe. We're going to do a panel so you can ask them questions. I will have questions for them. They know a lot more about ICWA than I do, so we will be able to hopefully answer any of the questions that you might have. And first, my background. You may not know, but I do not self-identify as Native American. And the reason that I bring that up is so much of the Indian Child Welfare Act is about what is culturally appropriate when you're providing active efforts, what the Native community believes is culturally appropriate. And I am not an expert or competent to talk about that at all. I know vaguely of some things that are culturally appropriate for tribes within our region. But that is a vague knowledge and understanding. I also don't know anything really about how tribal government works or the decisions that are made on the reservation by tribes. So if you do have questions about things like that as they relate to the law, Misty and Jill can do a much better job answering those questions than I can. My knowledge about the Indian Child Welfare Act is mostly legal in nature. And most of my work on ICWA has been through the ICWA Coalition, which is a group of stakeholders, before government headquartered tribes in Nebraska, Nebraska Legal Aid, again, Nebraska Appleseed, the Department of Health and Human Services. As of last year, county attorneys from Douglas and Lancaster County have been attending as well. We get together every month to talk about ICWA and ways we can improve the ICWA, ways we can work together to change things that need to be changed, or educate the folks that need to be educated. So that is where my ICWA experience comes from. And so with the ICWA Coalition and a lot of other people, we were involved in the efforts to pass LB 566 at the legislature last year. So my experience in the ICWA from a legal standpoint is mostly through the foster care lens and not the adoption lens. I do know some of the legal aspects of the adoption lens, so if you have questions about that, please feel free to ask them. But my expertise is mostly on the foster care side. So many of you already probably know that the Federal Indian Child Welfare Act was passed in 1978. It's codified at USC 25 USC 1901 through 1963, and it was passed in response to concerns about Native children being placed out of their homes at a very high disproportionate rate. Actually, about 1/3 of all Native kids in the entire country were placed in foster care in non-Native homes at the time the act was passed, so tribes literally feared for their survival. A year later, the BIA Guidelines were issued, and they have not really been changed in 30 years. But the guidelines provided additional instruction on issues about the applicability of ICWA, about how to do notice to tribes and parents or Indian custodians, the provisions for how to remove an Indian child, request to transfer a case to tribal court, placement preferences for Indian children, and requirements for adjudication and TPR cases. So some of you also may know the Nebraska appellate courts have consistently applied the BIA guidelines and have followed them. You may also know, for folks that have been around for a little bit, foster care has changed a little bit since 1978. So the BIA issued new guidelines this year on February 25th. And in doing so, they provided additional instruction on things like active efforts, custody of the child, imminent physical damage or harm. They have a great section on how emergency removals are supposed to work in the ICWA context, how transfer to tribal court is supposed to work, and then the requirements for adjudication and TPR in a case. And the new BIA guidelines, per the federal government, immediately replace and supersede the prior ones. So the old ones are no longer a thing anymore. The Nebraska Indian Child Welfare Act was passed by the Nebraska legislature in 1985, and it essentially mirrored the provisions of the federal act. And it made sense because the purpose stated in the act was to implement and clarify state policies and procedures to follow the federal law, which we try to do here. And there are certain measures Nebraska continues to do a little bit worse in compared to the rest of the country. We still have one of the higher rates of disproportionate Native children in our foster care system. The last time I checked, the National Council for Juvenile Court judges had us ranked the second worst. We flow between about 8 or 9 to 1 is the ratio of disproportionality for Native children in our state. So we have not been doing as well on that measure. So the goal in LB 566 is to modify and clarify some of the pieces of the federal act that had open questions. Even some things that are not open questions, the act kind of codifies a lot of our appellate case law to make it clear in the statute what the standards are going to be. And as you can see, the purpose in the new ICWA that takes effect on September 1st is essentially to make sure that we follow the federal act. But it also makes sure that our state is committed to protecting the essential tribal relations between and best interests of Indian children by following the federal law. And we're going to talk about how some of the provisions try to do that throughout the remainder of the presentation. Tribal presence. As I said before, we have 4 government headquartered tribes in Nebraska. The Omaha tribe, the Ponca tribe, the Santee Sioux Nation, and the Winnebago tribe. And we have representatives from 2 of those tribes here today. We also have several tribes that have reservation land in Nebraska, but their headquarters are not here. The Ogallala Sioux tribe, they have reservation land that extends into the state of Nebraska. We have the Sac and Fox Nation and the Iowa tribe also extending into Nebraska. But for all the practitioners out there, you may well know that ICWA knows no boundaries. If you are an Indian child, the ICWA is going to apply to you. Whether your tribe is in Alaska, Maine, Louisiana, it does not matter. the ICWA will equally apply to you. So we have, in the state of Nebraska, over 200 tribes represented by Indian children. All right, now we're going to get into the meat of the presentation. We're going to talk a little bit about some of the procedural changes that have been made to the ICWA. And that means we're first going to talk about inquiry and then move on to the legal representation of tribes. Nebraska now is going to allow participation of multiple tribes in certain situations in the ICWA, so that's an important change to note. And then there are additional notice requirements that are implemented by LB 566. So first, LB 566 requires the court to ask every family involved in a case whether or not they believe that an Indian child is involved. Under the statute, this happens to prior to the advisement of rights under 43-279.01, and it needs to happen in every single foster care case from now until the act is repealed. And similarly, every single call that comes into the DHHS Child Abuse and Neglect hotline, the hotline worker has to ask every single caller whether or not they believe an Indian child is involved in the intake. And then they have to document that information and report it to their supervisor. The BIA guidelines, the new ones that were put out on February 25th, also have some things to say about inquiry. And like LB 566, the BIA guidelines require the court to ask every party in a case whether they have reason to believe that an Indian child is involved in the case. And it gives the court some additional powers to order DHHS to do things that they may not have otherwise been authorized to order DHHS to do. DHHS generally tries to do these things, but may not in every case. But the court can order DHHS to provide detailed genograms, addresses and domicile information for Indian children or their families, and also order them to provide confirmation that DHHS was using active efforts to find out whether an Indian child was involved in a case. Also, the BIA guidelines have some things to say about DHHS in the inquiry that they have to make. And they also have to ask whether there's reason to believe that an Indian child is in the case. And if they are in the case, they have to obtain verification in writing from all tribes that a child may be eligible. So one of the interesting things about the new BIA guidelines, and we'll talk a little bit about this, but a court and DHHS are deemed to have knowledge that there is an Indian child in the case if, one, somebody tells them that an Indian child is involved in the case. That's an easy one. The next one is that the child themselves gives the court or the agency reason to believe that they're an Indian child. The third one, and this is a pretty broad one, if the domicile or residence of the family where Indian custodian is on the reservation, you're deemed to have knowledge that this child may be an Indian child. Also, if the child or family lives in a predominantly Native community, you should be on notice that the ICWA may apply in that case, or the court and DHHS should be. Finally, and this one's my favorite, it is pretty broad, but if an employee or agency of the court is involved in the proceeding, has actual knowledge that the child may be an Indian child, you're on notice that the ICWA may apply. So the example that I wanted to give in this case is if, say for example, there is an employee in the Child Support Enforcement Division of the Department of Health and Human Services working on a child support case. And through that, they find out that this family may be Native or is Native. They're an employee of the agency. And the CPS division of DHHS may very well be, or may very well have reason to know that an Indian child is involved in the case. So the various tentacles of DHHS or the court are going to have to communicate with each other going forward with the new BIA guidelines. This is also similarly discussed in Nebraska case law. This is an unpublished decision, Avery S. and Isabel S. But our court decided in 2014, our Court of Appeals, that the protections of ICWA have to apply when the state should have known that the children were eligible for enrollment. And I believe in that case it was pretty clear. There was a prior juvenile court case handled by the same court where the ICWA applied to those kids, and they did not apply the ICWA in the second case. So definitely the ICWA should apply at least if you've done an ICWA case with the same family before. We're going to move on to legal representation of the tribes. And so Indian tribes have a right to participate in any juvenile court proceeding in our state court system, and proceedings outside of our juvenile court system where it's a child custody proceeding under the Federal and State Act. So what that means is tribes are not required to be represented by legal counsel to participate. Their right of participation is absolute. What LB 566 does is it makes sure that there is no local council or pro hoc vice restrictions that are placed on tribes. This has been litigated in other states. Colorado state has lost, so this is insulating the state from liability, and now we can't get sued as a state for making tribes pay pro hoc vice fees. This also stems from Nebraska Supreme Court precedent. In re interest of the YSS, we concluded that a tribe's right, our Supreme Court did, to intervene under the ICWA preempts Nebraska's laws about the unauthorized practice of law. So the pro hoc vice fees and local counsel provisions of LB 566 also flow from the Elias L decision. This is the multiple tribes piece. So before, under the old ICWA, the ICWA defined an Indian child's tribe as the tribe in which an Indian child is a member or eligible for membership, or in the case of an Indian child who's a member or eligible for membership in more than one tribe, the Indian tribe with which the Indian child has more significant contacts. So the decider in the old ICWA was the juvenile court. LB 566 changes that a little bit, and it allows for the participation of multiple tribes in various parts throughout the Act. So in your handouts, you'll see that there are changes on LB 566 where it says tribe or tribes. Where it says that throughout the Act, participation of multiple tribes is okay. Things where participation of multiple tribes is not okay are things like transfer, placement preferences, and then filing a petition to invalidate. So things that logically, hopefully all logically, do not make sense where multiple tribes can participate. For example, two tribes probably cannot transfer a case to their separate tribal court at the same time. It just probably would not work out. So we have set up a model for determining which tribe is the primary tribe. And you'll see that language throughout the Act as well. And the first thing that tribes get to do when they're making this determination is make a determination among themselves. And when they're making this determination, the statute encourages them to talk to the family. Having a familial preference for a tribe is something that needs to be considered. But if the tribes are able to come to a unanimous decision about which tribe is the tribe that is going to be the primary tribe, then that tribe will move forward as the primary tribe. If they cannot come to an agreement, we go back to the old world where the juvenile court is the primary decider. The BIA Guidelines also talk about multiple tribes in an ICWA case. And in the new BIA Guidelines, they talk about things to use in determining significant contacts. So in the state of Nebraska, these factors are still going to be used by the juvenile court when the juvenile court is the decider, or should be. So some of the factors to be considered are parental preference, length of domicile, on or near a reservation, tribal membership of the custodial parent, interest asserted by each tribe in response to the notice of the case, membership in one of the tribes over only eligible for membership in the second tribe. There may be a situation, and this would not actually matter too much under LB 566 anymore, but under the federal guidelines, there may be cases where a child is not a member of one tribe versus eligible for membership in another tribe, but would be just eligible for membership in two tribes, not a member of either. And these are the factors that are going to be taking the court's focus when that happens. And similarly to LB 566, we have a model in LB 566 now where tribes can come to an agreement in any case. But if we didn't, tribes can come to an agreement where the child is not actually a member in one of the other tribes. Notice. There are not too many big changes to how to provide notice, but this is how the old version of the ICWA talked about notice. You had to do it. That's kind of everything that was said in the statute. And you have to notify the parent or the Indian custodian or the tribe in a case. And you have to notify them with certified or registered mail with return receipt requested. And you have to provide certain identifying markers to the native family, to the tribe, about the applicability of the ICWA. What LB 566 does is it breaks some of the things down and makes policy choices about how to provide notice. The idea would be that LB 566 more clearly provides the guidance to do notice. And the first thing is it makes a choice between registered or certified. In the state of Nebraska, under LB 566, it's registered now. It does not have to be certified, but it has to be registered mail with a return receipt requested. Also, the federal regulation that has governed notice the entire time that the ICWA has been law, which most people did not know about, and I did not know about until a couple of years ago, is 25 CFR 23.11. That provides the requirements for what needs to be included in all ICWA notices. And we have added some things with LB 566 as a state about what has to be included in a notice. So there has to be now a statement indicating what attempts have been made to locate the names and last known addresses of the Indian child, the parents and parental and maternal grandparents and Indian custodians, and if those names and addresses cannot be located, you have to document kind of what you did to go find them. Also, the tribal affiliation of the parents or the Indian custodian, a statement about whether the child's residence is on a domicile, or whether the child's is domiciled or residence is on a reservation, and then also identification of any tribal custody orders that are existing out in the ether, because if that is the case, our state court may not actually be able to take jurisdiction if the tribal court already has jurisdiction of a case. LB 566 also requires that notice has to be filed with the court. So when you're providing notice, if you're a guardian ad litem in a case, or if you're the county attorney or the department, you have to file that notice with the court within 3 days of sending it to the tribes, to the parents, to the Indian custodian. So the court's going to get a copy of the notice at the front end, and hopefully may raise some issues with the sufficiency of notice before it gets to the Court of Appeals or Supreme Court. And then also, we're going to talk about this in a little bit more depth later, but LB 566 also requires that notice be sent in voluntary foster care cases. LB 566 and the BIA guidelines make it fairly clear that ICWA applies in non-court involved cases. So as Nebraska has piloted a new form of child welfare services through alternative response, many of you are probably familiar with non-court involved cases. There are certain provisions of the ICWA that apply in those cases, and we're going to talk about that in a little bit of detail. Officially, things like intervention may not make a whole lot of sense since there's not a court proceeding, but we're going to talk about some of the requirements for voluntary foster care cases in the substantive changes part of the presentation. The BIA guidelines also clarify how notice is supposed to be made in an ICWA case. They also chose registered mail, similar to LB 566, and also made it clear that the notice should be in clear and understandable language of the family. So if the family is a Spanish-speaking family, the notice probably needs to be sent in Spanish. Also, they have some aspirational goals for things that should be included in the notice. And our Department of Health and Human Services does a lot of these things already, including detailed genograms or ancestry charts for both parents, including current and former addresses and all birth dates for all family members. Including information about the Indian child's domicile and residence being on a reservation or in a predominantly Indian community, protecting the anonymity of the parent if it is possible, protecting confidential information to the extent possible. They also require, the BIA requires that it be filed with the court, like LB 566 does, translating it to the language of the family, and also similar to LB 566, requiring notice be sent in voluntary cases. All right, now we're going to talk about some of the fun things, the substantive changes made by the Indian Child Welfare Act, BIA guidelines, and then LB 566. The first one of these is the definition of best interest. LB 566 defines what the best interests of a Native or Indian child is. And if you're looking at the statutory language, it requires kind of two key things. First, it is presumed to be in the best interest of the Indian child to follow federal state law. Any federal or state laws that protect Indian children, it's determined that that is in the best interest of the child to follow that statute. And then This is a nod to the placement preferences portion of the ICWA, trying to the greatest extent possible to place the child in a foster or adoptive home that reflects the unique values of the Indian child's tribe and is able to assist the child in establishing and developing and maintaining a political, cultural, and social relationship with the tribe or tribes and tribal community. The BIA guidelines, on the other hand, do not define the best interests of an Indian child, but do make one statement, and it's specifically regarding the placement preferences portion of the ICWA. The BIA guidelines have come out and said the provisions of the ICWA create a presumption that ICWA's placement preferences are in the best interests of Indian children, and therefore an independent best interest analysis would undermine Congress's findings. However, we have a state court case this year, Neary B, which concluded something to the contrary. That case concluded that there was good cause to deviate from the ICWA's placement preferences when a state court found that it was in the Indian child's best interests to remain in a non-native home. That Court of Appeals case determined that we have an independent best interest analysis in our state court system. So this is one area to watch in the future for litigation. And if you do have any questions about this, if you have a case that comes up involving a situation where the placement preferences may conflict, in your opinion, with the child's best interests, this is something to note. All right, voluntary foster care cases. LE 566 adds a voluntary foster care placement to the list of proceedings. It's in the definitional section of the statute. It explicitly lists non-court proceedings in which the department or the state is facilitating a voluntary foster care placement or in-home services to families at risk of entering the foster care system. So these are the two types of cases where voluntary foster care may happen. Some of you may know that the voluntary foster care cases, oftentimes the child will be placed in the home. The department will come in the home and offer technical assistance and referrals. They will try to connect the family to things in the community that could alleviate their situation, but the child may actually never leave the home. But the department has become involved. And some of the initial data we're starting to see in the alternative response program is that a lot of those kids, even when they're in home, may transition over to the traditional response model. It makes sense if there is a home that there is kind of some safety concerns and the department is in there on a weekly or monthly basis observing that family, they may be more likely to enter traditional foster care or have an abuse and neglect case. So the state statute now requires that we start doing some of the things in the ICWA when the state first gets involved with a family. So active efforts is going to kick in right away. Also, tribes have to be notified that the department is doing in-home services with the family. And the tribe also has a right to come in and participate. Like I said, intervention and transfer may not make sense because there's not an actual court case yet. But the tribe can come in and provide culturally competent services to the family and connect the family to resources that the tribe may have that could alleviate their situation. So that is the intervention provisions of the ICWA. It's a modified way to do it. If the child does have to go outside of the home, the placement preferences of the ICWA in a non-court involved case apply. Also, there are additional procedural assurances for relinquishment and termination of parental rights arising out of voluntary foster care placements. So essentially, if the department comes into a home and has a case where they do not have a court-involved case, but it is a voluntary foster care situation, and the family is eventually convinced that I want to give my rights up to this child, we're going to do an adoption. There has to be additional information that is put before the juvenile court about what the department has done and how ICWA has been complied with in the non-court involved case before the adoption can happen. The BIA guidelines also make a similar policy choice and determine that ICWA applies in voluntary proceedings. The BIA guidelines are more broad in that they are specifically talking about voluntary foster care placement proceedings and voluntary adoptions and guardianships. But in all voluntary proceedings, according to the new BIA guidelines, the court and agencies have to first, we've talked about this, ask if there is an Indian child involved, and then also provide notice to the tribe of the proceedings. May or may not happen in a non-juvenile court scenario with the private adoption, so the BIA guidelines make it clear that that has to happen now. All voluntary proceedings have to be executed in writing before a court, and they put examples within the BIA guidelines about how to do that, how to explain the consequences of what's going to happen to a parent, how to certify those documents, and there's actually a lot of things in there about parents consenting and what needs to be included properly in a consent form that needs to be put before a court. And then also, they make it clear that the notice, intervention, and active efforts provisions of the ICWA apply to diversion, differential, alternative response, or other program. So the BIA guidelines are pretty similar to LB 566 in this respect. ICWA has to start applying before the kid comes into the foster care system, once the state involves themselves with a family. Active efforts. So the ICWA previously did not define active efforts. It's pretty different in jurisdiction to jurisdiction about what could be considered active efforts, but generally the only statement about active efforts in the old version of the ICWA is that they have to be provided, and you have to satisfy to the courts that active efforts have been provided, to provide remedial services and rehabilitative programs designed to prevent the breakup of an Indian child, and that these efforts have proved unsuccessful. LB 566 goes a little bit further than that. It provides a list of things that meet the active efforts requirement. Some of these things, such as providing a concerted level of casework prior to and after the removal of an Indian child, consistent with the social and cultural conditions of the Indian child's tribe and way of life, a request to the tribes to convene traditional and customary support and services, actively engaging, assisting, and monitoring the family's involvement and access to culturally appropriate services, identification of and provision of information to the child's extended family about the case, and also about community and state resources that the extended family may be able to access to make their home safer. So how I'm reading this would be, if you find a great placement, an aunt that is very loving for a child and has a little bit of trouble paying the heat bill, the department may be actually responsible for connecting that extended family member to go to the LIHEAP program through the state to get assistance to pay for heating, because they need to provide that sort of assistance to extended family members now when it benefits the Indian child. Also, the identification of and attempts to engage tribal representatives, consultation with extended family members to identify family or tribal support services, and exhaustion of all tribally appropriate family preservation alternatives. So essentially, it is requiring the department, or actually in most cases the department is the party that is providing active efforts, but they may not do it in a certain case, and if they're not providing active efforts, if you're a guardian ad litem to your satisfaction, I would probably start doing some of those things myself, especially if I don't want the child to be in one of these ICWA placements, or we're going for a TPR or foster care placement, and I see the department doing things subpar to my liking, which they sometimes may do, I would start doing some of these things myself and documenting it. Because LB 566 provides additional provisions to ensure that active efforts are put before the court in every case. So the first thing that I'll talk about is the department or state is required to provide a written report of everything that they've done to provide active efforts at every hearing involving an Indian child, and any party that is seeking to effect a foster care placement of, or TPR, they have to satisfy to the court that, 1, active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, or 2, to unite the parent and Indian custodian with the Indian child, and 3, that these efforts have proved unsuccessful. And so you may notice the change here with this one word, unite. And for those of you that are familiar with the United States Supreme Court decision in the baby girl, adoptive couple v. baby girl case, this is some of the language that they focused on to determine that Dustin Brown, the father in that case, was not an appropriate person to give active efforts to. And so we think under LB 566, you may have to provide active efforts to Dustin Brown to the extent that they're possible under the circumstances, which is the next provision we're going to talk about in the new act. Or actually, first let me step back and just say any written evidence that you have in a case that active efforts is being provided is deemed admissible. So anything that you write down showing that there may be active efforts provided to a child, it's per se admissible in our Nebraska juvenile court system now. But the standard in ICWA has changed. So you saw that, or clarified, I should say, not really changed, because this is based on Nebraska court precedent in 2009. There's a case called In Re Interest of Louis S. And that case determined that you do not have to provide futile efforts. So in any case where providing active efforts would become futile, the active efforts requirement of the ICWA is satisfied. And this is what has been codified here. So you have to show, in order to do a TPR, foster care placement, that one, you've actually provided active efforts, or somebody has, to the family and child to prevent their breakup, or to unite them, or that the party seeking placement or termination has demonstrated that attempts were made to provide active efforts to the extent possible under the circumstances. It is clear since 2009 you don't have to do the impossible. The department doesn't have to do the impossible in ICWA cases. What you do have to do is, under LB 566, you got to give it a shot. And you got to write it down and give it to the court and explain to them how you've tried. And if you can't actually provide active efforts to a family, you don't have to do it. So anything that was on the list in our definitional section of LB 566 that is impossible. So something that may be on there that would be really difficult to do is engaging and reaching out to a tribe in Alaska that has one caseworker and 600 cases, and connecting that child to culturally appropriate services through engaging that family's tribe. Well, if the tribe doesn't actually call you back, there's not a whole lot you can do to connect that family to the tribe. But you have to try. And you have to write it down, and you have to tell the court exactly how you tried to be in this world right here, where attempts were made, but it wasn't possible under the circumstances. So, under the private adoption scenario, in the Supreme Court case, adoptive couple v. baby girl, this is what would kick in. And actually I have a quote here, because the language that was used by the majority of opinion in the baby girl v. or adoptive couple v. baby girl case was very broad. It was a contentious decision. I think you may be able to count the times on one hand where Justice Ginsburg and Justice Scalia are on the same side of an issue. This is one of those cases. But Justice Breyer had an interesting concurring opinion which severely limited the scope of this case. And the quote that I'll read here was, first, the statute does not directly explain how to treat an absentee Indian father who had next to no involvement with his child in the first few months of life. That category of fathers may include some who would prove highly unsuitable parents, some who would be suitable, and a range of others in between. Most of those who fall within the category seem to fall outside of the scope of language of the ICWA. Thus, this case does not involve a father with visitation rights or a father who has paid all of his child support obligations. Neither does it involve special circumstances such as a father who is deceived about the existence of the child or a father who is prevented from supporting his child. There were two prongs in the baby girl case. One was active efforts, one was serious emotional and physical damage. LB 566 is only talking about active efforts. But it also makes it clear that ICWA is going to apply to an absentee father when it is possible to provide that person active efforts under the circumstances. If a dad does not want to be there or cannot be located, you're going to be able to try and show that it's not possible to provide that person active efforts. So in the private adoption scenario, such as what happened in Adopted Couple v. Baby Girl. If there's any attorneys practicing adoption law out there, I would suggest calling father, putative father, letting him know that this is going to happen well before the baby's born if you can. And ask him if he wants to be a part of that child's life, so you're going to know which set of laws are going to apply. If he wants to be a part of that child's life, it's probably going to be possible to provide him active efforts. If he says, no way, I'm out of here, I don't want to be involved, I think it's probably not going to be possible to provide active efforts to unite that family under the circumstances. So that is one of the bigger changes made by LB 566. I've been talking a lot. Let me just pause really quick, because that's kind of a heavier piece. Does anybody have any questions about this or anything else that we've talked about so far?
I'm just curious, trying to kind of, having read the legislative history of various bills before, I'm trying to figure out, like, what was the guiding motivation to LB 566? What are the problems or the abuses that it was trying to solve?
Great question.
Could you repeat the question for them?
Yes. So the question for those of you in TV land at home is, what was the legislative history or the guiding reasons behind LB 566, and why our Nebraska legislature felt it was important to act on this issue? And I think there are several pieces. One would be Nebraska's poor rate of disproportionality. So the ICWA globally is intended to reduce disproportionality. Nebraska has about an 8 or 9 to 1 ratio of Native kids versus the general population in care. So I think the global motivation was we need to do a better job with ICWA cases. The second motivation is that we have a lot of, or arguably there's been a lot of uncertainty about how the ICWA should be read. And we have as a state have handled a lot of ICWA issues, and I'm sure that will not fix everything, the statute, but a lot of issues that are judicially decided. And attorneys out practicing may not know about all of those judicial determinations that we've made since 1978 about how to proceed with the ICWA. So the second goal was to be more clear in how we're going to provide ICWA or ICWA services and comply with the law to attorneys out in the community. The third piece, and this is more anecdotal, but as the ICWA Coalition had been working on ICWA cases, we tried to identify things that were easily fixable through legislative language, and worked with Senator Koash and a bunch of other interested senators to kind of grab the low-hanging fruit, things that we as a state can do better, but in anecdotal experience have seen a lot of people mess up over the course of time. So essentially, I think the big goal is we wanted LB 566 to read as a how to comply with the ICWA guide. Where external legal research, we're going to look at obsolete federal regulations may not be as necessary as it used to be. Did that answer? Oh, no problem.
Do you have a microphone? Because we have a lot of
banging. I will enunciate more. Thank you. I don't think we have an internal microphone. There's one. Hopefully the people at home are able to hear, but I will. Yeah, there's a lot of banging going on next door. I'm a loud person. I have no problem being louder. All right, moving on. We're gonna.
Bobby,
oh,
I have a question.
Yeah.
So when you say written evidence of active efforts is per se admissible, what would you say to practitioners, say parent attorneys who want to challenge what efforts were actually made? Does the department get to just submit a report that says we did this and it was active efforts and it was unsuccessful without any challenging?
Good question. So the department does get to submit their. Oh, sorry. Thank you. The question was, does the department essentially get to submit a written report about what they've done, and the judge will take that as the gospel about providing best interests? And then the answer is maybe. I don't think so, though. If I were a parent's attorney wanting to challenge something the department had done with active efforts, I would try and present information that maybe something in the report did not actually happen. So If the department claims to have reached out to a tribe to request traditional or customary support on 3 separate dates, and they spent a ton of time doing it, and I myself called a tribe and the person says, yeah, we talked to him once for about 5 minutes, and they didn't really ask a whole lot of questions, but they said that there was an NICWA case and we sent you notice, what are you guys going to do? I would go out and get an affidavit from that person stating we really did not meet the active efforts requirement of the statute. So that's how I would combat it, but I guess the different courts may take the word of DHHS less or more seriously depending on where you practice. Some courts may be naturally more skeptical of what the department is saying. Some courts maybe won't be. Yeah.
With respect to some of these changes and, trying to get the tribe involved from the beginning, because I think in general that's best for children if you want to provide these culturally significant efforts as opposed to when a termination is filed or your 3 years or so on the case. My experience has been that, sometimes the tribes, like you said, have a lot of cases, notices received, and they do not become involved in the case unless there is a termination of parental rights. So is there going to be any kind of changes in the way the tribes handle things or their manpower, their ability to participate more actively in this kind of thing?
Great question, and actually a large part of that I will kind of defer to Jill and Misty to talk about during the panel discussion. I think the goal of LB 566 more globally, so you may have noticed that there was only a, oh, sorry. The question is, how will LB 566 more strongly encourage tribes to get involved from the beginning of the case as opposed to waiting till the end of the case? Would you say that's a fair recharacterization?
Yes.
Okay. So LB 566, very generally speaking, requires the state to do more, to provide more information to the tribe, so the tribe may be able to spend less of their resources finding out what's going on in a case and more of their resources getting involved. LB 566 did not have a very large fiscal note. So there is not money actually being provided to tribes by LB 566 to boost tribe social services programs. That was not what the statute was intended, and the makeup of the legislature makes seeking funding sometimes more difficult than others. But the first prong, LB 566, is, in my opinion, a first step to address some of these issues. And in the future, something that really needs to be addressed is how tribes can receive more adequate funding to do the services that they need for kids. So that is kind of a next step legislative thing. But it's also a difficult question to answer, too, because there's a lot of tribes where I don't know if the Nebraska legislature may appropriate funds to send to South Dakota or to Oklahoma to boost other states' tribes' services. And for practitioners out there, you may know that we have a very large presence of Native kids in our communities from South Dakota. So providing funding, I think Misty would like it if Santee had a little bit more funding, but it wouldn't necessarily solve problems with other tribes in other states receiving less funding from their own states or the federal government to run their social services division. Again, it's a first step, but I don't think it entirely solves the problem of resources, something that hopefully will be solved in the future. And Misty and Joe can talk about that a little bit more as we get to our panel discussion, because, again, something I don't know a whole bunch about. Other questions? All right. So, active efforts under the BIA guidelines. The BIA did a similar thing to LB 566. They included a non-exclusive list of what may be encompassed by active efforts. So the difference between what LB 566 does and what the BIA guidelines do, LB 566 essentially says you must do these things, and then later on in the statute says to the extent they're possible under the circumstances. The BIA guidelines provide a non-exclusive list of things that could be active efforts. So to the extent that some of these things are different, but it may be helpful in your individual cases, I would consider providing these services that are listed in the new BIA guidelines in section A2. Placement preferences. And so we're going to talk a little bit here about how placement preferences, that part of the statute, works generally. So first, the placement preference for Indian children for both adoptive and foster care placements under the ICWA has always, the first option has always been extended family members. And under the ICWA, tribes have the ability and the right to define who is extended family for that tribe first. Then the language of the ICWA kicks in if the tribe does not have their own definition. So if no tribal definition exists, the ICWA defines extended family members as a person who has reached the age of 18 and who is the Indian child's parent, grandparent, aunt or uncle, clan member, band member, sibling, brother-in-law or sister-in-law, niece or nephew, cousin or step-parent. And so you may have noticed that there is nothing in this definition of extended family saying one of these people have to be native. So this definition clearly includes both Indian and non-Indian relatives. And the legislative history indicates that where possible, an Indian child should remain in the Indian community. But it is, this section is, and this is legislative history from the Federal Act, by the way, but the section is not to be read as precluding the placement of an Indian child with a non-Indian relative. So, relative placements, as many other parts of the statute for non-Indian kids, are preferred over non-relative placements. How LB 566 changes this a little bit is it adds additional categories for the placement preferences under the ICWA. So, we're looking here at the adoptive placement preferences, and you may see that there is a new preference added, and also that we have the language here requiring or stating that each one of these placements are in descending order of priority. So, this now, a non-Indian family committed to enabling the child to have extended family time and participation in the cultural and ceremonial events of the Indian child's tribe or tribes, is something that is allowed under the ICWA, and you do not need to show good cause to deviate from the placement preferences. So what this essentially means is that tribes now have an ability to stay connected to their children, and there is an option before going directly into stranger care where the family is not committed to connecting the child with the tribe in their political and social relationships. And so this was added. This is not in the federal statute. This is LB 566 in our state statute only. Also, we changed a little bit of the definition or the placement preferences for foster care placements. And as you can see here, LB 566 adds in the same placement preference above residential or institutional placements. And so, again, a non-Indian family committed to connecting the child to their tribe or culture is an okay placement preference without having to show good cause to deviate from the placement preferences. And in fact, since this is also in descending priority order, it is placed above the residential or institutional placements because tribes and the folks that worked on LB 566 believe that family placements are preferential to placements in a residential or institutional facility when it's possible. So that is brand new. You won't see that in the BIA guidelines. Good cause to deviate. So we just talked about this a little bit. Generally, for those of you who may not have had ICWA cases before, in order to deviate from the placement preferences that are listed in statute, you have to, the person urging that the statute or the placement preferences not be followed has the burden of showing that we shouldn't follow them. And before, that had been undefined. This is less of a critical change to the statute because our state appellate courts have consistently applied the older BIA guidelines, and that is what is essentially codified in the good cause to deviate section here. This is almost word for word what comes from the 1979 BIA guidelines. And so a person trying to argue that you should not follow the placement preferences and you are going to place the child outside of the family, or outside of the listed placement preferences, an adoptive or foster care placement, you have to show one of these three things. First, if the biological parents of the Indian child don't want to follow the placement preferences, that may be good cause to deviate. Also, if the Indian child at the age of 12 determines or decides that they don't want to follow the placement preferences, that also may be good cause to deviate. The extraordinary physical or emotional needs of the Indian child as established by testimony of a qualified expert witness. What this could mean in practice is the placement preference could be on the reservation, and you may determine that this child really needs access to high-level, only available services in the city of Omaha. At UNMC is the only place where this child can get the services, and they're going to have to commute 5 hours each way every 2 days to get the placement, or to get the treatment that they need. And so that may be good cause to deviate from the placement preferences. Then the unavailability of suitable families for placement after a diligent search has been completed for families meeting the preference criteria. And again, if you are trying to argue that the good cause to deviate part of the ICWA applies in your individual case, I cannot stress enough the importance of writing it down, what you have done, what has taken place for the diligent search, what the department has done, if you want to try and argue that there are unavailable placements within the placement preference criteria. And that's kind of the underlying moral of the story for most of LB 566. It requires, you will never go wrong for trying and writing it down and explaining to the court how you tried. So it's always a good idea to do that. And question?
Yeah, could you go back one?
Sure.
I'm curious as to how many disputes actually happen at the first level between extended family members who are Native and extended family members who are not Native. And I'm also curious as to, you'd think that that would have been the first distinction, that there would be an extra level in there. But also, when it comes to the definition of extended family, do arguments come up saying, well, I'm a closer relative than that person, so therefore I should have some priority? Or is this all basically mostly between the tribe and government?
That is a fantastic question again. And for those of you listening at home, I'm going to completely defer this and not answer it at all. But I'll try to answer it. The question is essentially, in this first level of the placement preferences with extended family, one, are there disputes about within the extended family with who is Native and who is not Native, when you are both within the definition of extended family? And then two is whether or not there are arguments within this level of the placement preferences about who is a closer relative to the child. So this is entirely speculation, and I could be completely wrong. But I think that definitely seems like it could occur within a case. How I would go about solving that is, first, I would argue that if you were within the extended family and you were a parent of the child, then parental preference should trump other things and other relative requirements. Two, there was a great bill passed by the Nebraska legislature also preferring kinship placements for family members. I would look to that statute because many of these other members of the child's extended family are probably kinship placements, and that statute focuses more on who the child specifically has had a relationship with in the past. And so if, say, for example, you were aunt to the child, and the child had come over to your house for brunch every day for 3 or 4 years, or every weekend for 3 or 4 years before the case, and then uncle on the other side of the family was disputing it, and he lived, this is an easy one to argue, but lived on the other side of the country and they had met once. I think you may be able to argue that the kinship requirements within our Nebraska legislature for parental or placement preferences should be a guiding force to make that determination. So again, what would be the best for the child is usually how this should work, and how I would argue it would work is the person that's known to the child would be the better placement, or more known. But Jill and Misty can correct me if I'm wrong. Yes?
What you just said now, what would be best for the child, that's exactly the question that comes to my mind. How does the concept of best interest plays with the limited good cause, and even to move within one priority to the next, it says it's in the best interest not to follow these, but to move down the line, or whatever the case may be? Or doesn't it play at all, and you just have to do this, period?
Good question. And so I think the statement by the BIA guidelines may be most illustrative as to this point. Congress has essentially, what they have done is has said these placement preferences are in the best interests of Indian children. And they have made that determination for themselves. But within the levels of care here, and I didn't repeat the question, did I? For those of you in TV land at home, the question is whether or not the placement preferences incorporate the best interests of the Indian child, because, oh, there we go, because they list out a group of people that can be a placement for the child, and then if you do not meet one of the criteria on this list, or not an entity or person on this list, there are only 3 reasons listed to deviate from this list. And so the policy choice has essentially been made by Congress, or in our case, the Nebraska State Legislature, that we should be able to find somebody on this list. And if we can't find somebody on this list, there's 3 reasons why it may not work. The biggest one may be the unavailability of suitable families for placement. Specifically, adding in the additional placement preference by the Nebraska legislature may help to deal with some of those issues. Where you are working on a case and you have a great foster family, they're working well with the tribe, they are connecting the child to their tribal culture, this additional placement preference should be able to kick in and it would work. But essentially the best interest of the Indian child, the short answer, should be incorporated by the statute. It takes a little bit of discretion outside of the, yes, exactly. The statute is taking away judicial discretion. And I'm sure members of Congress and our state legislature can say this better than I can, but they are making the policy choice to take it out of an individual judge's hands to some extent, because it is really difficult in many cases to find where this would not be in the best interests of the Indian child. So with that being said, it's essentially a decision that we don't necessarily want non-native, which a majority of and you guys can correct me if I'm wrong, but my speculation is in 1979 with the problems that existed, Congress decided we may not want a bunch of non-native judges or non-native caseworkers specifically obfuscating what we have said should be in the best interest of Indian children, because I have determined that it is so, without maybe having the specific knowledge about how the tribe works or what exists on the tribe. It makes it a little bit more rigid, but I think that is the underlying justification behind it.
You said there is a case recently that has said we're still going to do what we think is in the best interest, but maybe it was in a different context.
It was in a little bit of a different context, but also not really. So the Neary v. case, it was about they incorporated an independent best interest analysis, and they chose to place the child with their continuing foster family as opposed to their maternal aunt because of several reasons. Mostly the court cited socioeconomic reasons. The aunt was not ready to have that many children in her home, and the child was really connected to their foster family. But the kicker is, in that case, they probably would fit into, the foster family in that case probably fits in here under the new statute.
Do you have a reason to move to that? Like, wouldn't the aunt be out there?
The only reason so these are in descending priority order, but you don't have to make an individual showing of good cause to deviate each time you move down a level. So we should look to this one first, extended family. That is taking priority, but I don't have to go make a showing that
There is
good cause to deviate. Right. So these are levels to be considered in descending priority order, but the judicial showing is only made when you get down to this one, and none of these on the list are suitable. Then, and only then, is when you move to the good cause to deviate section of the ICWA. And again, Jill and Misty, you guys can definitely correct me. I did. Jill and Misty. And we could talk a little bit more about the good cause section to deviate, but we're going to move on to QEW. So qualified expert witness, in an ICWA case generally, qualified expert witnesses are required to testify at every single case where you're seeking a foster care placement or a termination of parental rights. And our state statute now defines QEW, or qualified expert witness, where it did not before. And you may recognize some of this language here from the old Bureau of Indian Affairs Guidelines, the 1979 ones. There are additional professionals that have been added, but this is also in descending priority order. You can go ahead and read through these at your own pleasure, but our Supreme Court and Court of Appeals generally have followed these when the issue has been raised very closely. In the old BIA guidelines, there were only 4 people that would qualify as a qualified expert witness. Here we have 6. 1, 2, 3, 4, 5, 6. And you can see here, this is a catch-all that has existed since 1978. This is how you can have, and I've lovingly called this individual Bob the psychologist, Bob the psychologist has never been to the reservation, has never worked with Native kids. If you can't find somebody else on this list, you can go to Bob in every single one of your cases. What this is not letting you do, you can't call Bob right away. You need to call somebody that is a member of the Indian Child's Tribe first. And what the statute also makes clear is that the court still has the ability to assess the credibility of individual witnesses. So Bob the psychologist, if there are dueling witnesses, can be really persuasive. And maybe a person here, a member of another tribe who is recognized to be a QEW, but can't really speak to what the Santee Sioux Nation does. That person, the judge may decide, is less credible about what's going on within that child's tribe than Bob the psychologist is. So the court still has freedom to exercise a little bit of discretion here, but this is a broad list of folks who can be QEW, and you can always call Bob the psychologist. He can be a QEW as well. The BIA guidelines also make a smaller list of individuals who are determined to be qualified expert witnesses, and it's non-exclusive. So you may notice Bob the psychologist is absent from the BIA guidelines list. Bob the psychologist is called in a lot of ICWA cases and is the first person called, and that was one of the major complaints that were heard when the BIA went out and took testimony from people that are practicing in this areas. Well, they don't even call the tribe to find out if we have a member that's a QEW. They just call Bob the psychologist first. That's not a thing on the national level anymore. But it is a non-exclusive list, so it's an open question of whether Bob the psychologist can still be a QEW. In our state court system, with negotiations between Senator Koash and the county attorneys, we always can have a QEW in every single case. They may be Bob the psychologist, but we certainly prefer that they have some knowledge about Native culture and Native people. Microphone? All right. I probably haven't been doing a great job of being too loud.
I'll be off the roof in about 10.
Okay.
The second one.
Awesome. So, all right. This is really brief. Nebraska specifically put in here that in OB 566 that emergency placements count under the ICWA. That has been pretty clear with national case law for the last 30 years, but it hasn't always happened. Specifically, South Dakota was having some issues with this, but Nebraska specifically put it in here that emergency removals, the ICWA still applies. But the BIA guidelines go through and make a lot of additions and specifically dictate how individuals should handle the emergency cases, how active effort should be provided in those circumstances. And I see we're running a little bit short on time, and I want to leave time for our panel, but you should go read the BIA guidelines on the placement, emergency foster care placement, if you have any questions about how it should be handled in an ideal world. All right, we can go through these pretty quickly as well. These are some of the additions that were made by the BIA guidelines, and there may be some of you that are really interested in one of these, just my guess. If you could wait till the end to talk about these, we'll just get through these really quickly and then have about 10 minutes for Q&A before we move on to the panel, and then we'll have an open Q&A to everybody. But a couple of things that LB 566 did not do. It did not make a statement about the ICWA applying to juvenile delinquency cases. The BIA guidelines do. The ICWA now applies to some juvenile delinquency cases according to the BIA guidelines. Second, the BIA guidelines specifically stated there is no aggravated circumstances exception to the Indian Child Welfare Act. Third, the BIA guidelines said there is no existing Indian family exception to the Indian Child Welfare Act. So we'll start with the juvenile delinquency one. So ICWA, according to the BIA guidelines, may apply in juvenile delinquency cases. This may be contrary to what you were used to before because some of the language in the definitional section of the ICWA specifically says ICWA does not apply to cases where it would be a crime if you were an adult. The BIA guidelines take a more nuanced approach, and we can talk about this in our question and answer section. But for those of you who may have been practicing for a while, it may have not been a very common practice to place kids generally in foster care placements. Back in 1978 when the BIA guidelines were being promulgated and the statute was being written. It is a relatively common thing now for somebody that is a juvenile or has a juvenile delinquency charge to be placed in foster care. The BIA guidelines now say for those kids, the ones that are placed in foster care, not necessarily the YRTC, that probably wouldn't be a foster care placement, the ICWA should apply to those kids now. And if you are looking for a definition of foster care that the BIA guidelines do not specifically cite themselves, but may determine who is in foster care, you can find that at 42 CFR 1355.20. And it defines foster care, so things like group homes count as foster care. Family homes clearly count as foster care. And this is, again, speculation on my part, but my guess is the BIA was thinking we're trying to avoid that situation where we may have an individual case where that person probably should be duly adjudicated. They have a lot of family issues at home. There's a lot of parental issues going on. But it might be a lot easier to just charge them on the criminal side because then we would not have to comply with the ICWA. We could have all the same results. We can have them placed in a foster home out of the dangerous situation and keep the child safe. But we may not have to let the tribe know. So that is my speculation of what the BIA guidelines were trying to get at. That could be completely off, but that's just what I'm guessing. Next, the aggravated circumstances exception to the ICWA, or any exceptions to reasonable efforts made by ASFA, do not apply to the active efforts requirement of the ICWA. The guidelines are clear. The BIA guidelines were drafted, or the statute was drafted, actually. Active efforts were a creation, essentially the reasoning goes. Active efforts were created before reasonable efforts in the ASFA in 1997 was officially the federal language. And so if Congress would have wanted the exceptions to apply to the ICWA as well, they would have explicitly said so in 1997 when ASFA was passed. Since that did not happen, the reading goes then, those exceptions do not apply to ICWA. We actually have Nebraska case law supporting that argument. Nebraska Court of Appeals in 2010 heard in re interest of Jamea M. and determined this was the case. It was subsequently reversed by the Nebraska Supreme Court. Sorry about that. It was subsequently reversed by the Nebraska Supreme Court, and then on unrelated grounds, but it vacated the judgment in the case. So there's some question about whether this is good law now, but the BIA guidelines agree with our Court of Appeals. Moving on to the last one, The existing Indian family exception. This is a judicially created doctrine, first recognized by Kansas in the mid-'80s, and it was essentially goes that if you are an Indian child, but you don't really have significant contact to the Indian community, then ICWA shouldn't apply to you. That has been problematic because people that make that decision are, again, not native, not a member of the tribe, not a member of the child's government who has a sovereign ability to make that determination. So actually, it's a minority of courts that are actually currently applying the existing Indian family exception. Kansas is where it was created. Kansas has since come back and said, we really don't want to do that anymore. So we are pulling back, and they do not apply the existing Indian family exception anymore. And now, according to the BIA guidelines, this is forever barred. And these are some of the considerations that they explicitly concluded are inappropriate, even though the general doctrine is this does not work anymore under the BIA guidelines. But these are some of the things that courts used to determine in those states, in determining how Indian you actually were. And generally the BIA and Congress feel that only tribes should have the ability to determine who is an Indian as that child's tribe. So the last section was pretty quick, so we can talk a little bit about this if you guys have questions about the last section or anything generally before we move on to the panel discussion. So questions from the crowd?
The guidelines are not binding, so is that going to be applied in Nebraska?
Good question. The question is, the guidelines are not binding, so are they going to be applied in Nebraska? The answer to that question is probably to the extent that they're persuasive, which was how the court applied the old BIA guidelines. That being said, Congress also, about a month after these BIA guidelines, not Congress, the BIA, about a month after these guidelines were released, officially promulgated them as enforceable federal regulations. They have not gone through the notice and comment time period, and they have not revised them yet. So they are not finalized, but they are very closely related and in many cases identical to these new guidelines. So for now, until those regulations become final, this would operate just like the old BIA guidelines do. Our courts have found them persuasive and followed them in many cases. Other cases, like the Neary v. case earlier this year, not as much. But it may actually be enforceable federal regulation sometime within the next 12 to 18 months.
But Robbie, there could also be changes to the final rules. So these BIA guidelines are in effect now, so they're persuasive now, but if there are changes, we'll all have to pay attention to the final regulation.
Right.
And switch our brain one more time.
And what Sarah was saying, is if the federal regulations do become effective and are promulgated with some changes, we're going to have to reevaluate some of the things that are going on. Right now, the regulations and the guidelines seem to be fairly consistent with our state statute, but if there's a crazy change that deviates it would deviate to a large extent from the current regulations, they may actually have to go through a subsequent notice and comment period, and we may have to wait another 12 to 18 months to see if the regulations come through. Yeah.
So in the delinquency case, I mean, this is a fairly recent change, so I don't know because it's really been tested yet, but in Nebraska, it used to be that OJS handled kids who were placed on probation, and now all that is handled through the Office of Probation Administration. And I can envision bringing up active efforts and this whole idea of probation and just getting like stairs. Has other states sort of dealt with this in delinquency proceedings that you're aware of, or how does that work on the delinquency side?
That is a really good question. So some states, and this is my very vague and limited knowledge, so I apologize. It's not very much. Oh yeah, sorry. So the question, thank you. The question is, thanks Misty. The question is, have other states had the opportunity for their OJS side, which is now handled by the Office of the Courts, had the opportunity to do things on the vehicle, provide active efforts? And so, yes, I think our Office of the Courts may have some limited experience too, because it's been clear that the ICWA has always applied to status offense cases. So if it is a status offense and your state chooses to operate similarly to Nebraska, they would have some or limited experience in working with the ICWA. Certainly not as much as the Department of Health and Human Services, but in some states they probably would have some experience. But they're probably going to need to get the memo on these changes too, because this is going to affect them. Yes?
In delinquency cases, where are we looking at, when are we looking at notice to drive?
Also a very good question. So it depends, I think. And this is all, again, speculation, and I've talked to some of my national friends about when
Can you repeat the question?
the notice requirements of the ICWA, which is the question, would apply in juvenile delinquency cases. And again, it's not clear in the BIA guidelines how that would work. My initial take on it is it would apply from the beginning of the case if that's what you were seeking from the beginning was a foster care placement. So at the beginning of the juvenile delinquency case, that first hearing where you're going to decide, well, we're going to seek to send this child outside of their home or to a group home. We're not going to have an in-home case. We're not going to send them to the YRTC. That should be the moment where notice is sent. If it happens later in the case, that is a little trickier. So if you have a kid at the YRTC, that's the first place that they go, and it is actually not safe for them to return to their home after they come back from the YRTC, and you have a county attorney that doesn't want to file 3A charge or 3A case to the child to be duly adjudicated. My guess is the notice requirements are going to kick in right after the kid's coming back from the YRTC and going into a foster care placement. So that's my best guess, is right when you know it's going to be a foster care delinquency placement. It's dependent on where the child would go. Yes?
Is there any concern that Indian children are less safe than non-Indian children when it's required that there's an imminent physical harm rather than standards that are currently?
Oh, and the question is, are there any concerns whether Indian children are less safe because the standard for the ICWA is you cannot do a placement, foster care termination, unless there's an imminent risk of substantial physical or emotional damage to the child. I have not seen a case where that has happened personally, so I can't really speak to it. There may be, but I'm not aware of any cases where it would be.
But I mean, was that part of the thought process? Was that considered at all?
And again, the follow-up question is, was that part of the thought process or considered at all? And my guess is that, again, I can't go backwards to 1978 to think about what Congress was thinking when they wrote the statute. I could try my best. My guess is that they were thinking that the child's safety is a paramount issue, but once it gets to the level where the child would have, and this is a standard that does not really apply in non-ICWA cases, so it's kind of hard to have a null group of people where the same standard would apply across groups. But I honestly don't know. So it's a good question. Yes?
I just want to make a comment. At least my understanding of the reason for a higher burden of proof is because you want to make it more difficult for Indian children to be removed from their homes. Not necessarily that they're in a worse situation, but typically when you're going to remove a child, whether it's Indian or not, it's because there is a concern. But the point of that was to make it very clear that there is no other alternative but to remove.
Yeah.
At least that's my point of view.
And I would just add that that's the direction that the state's going as well with AR and some of the voluntary cases, is to try not to remove unless there is a safety threat that rises
It's a different burden, though. It's a serious risk of harm, not imminent.
Yes, and yeah, the burdens are different. And again, I think that was Hazel Rodriguez from Legal Aid with a really good answer, better than what I could come up with. Essentially, Congress did want to make it harder to remove Native kids than any other group.
I wonder if there's ever been any research done, though, on Indian children who are physically hurt because they were left in a situation where another child might have been removed.
And yes, and that was specifically, if there had been research done about ICWA cases where an Indian child would have been hurt, if and only if the ICWA was hurt because the ICWA was there. I am not aware of any scientific research, any sociological research, or any anecdotal evidence of that being the case. So it may be out there, but I am not aware of anything stating that. Other questions? All right, great. So I'm going to open this up to our panel discussion. This is, again, Misty Thomas. She is the Director of Social Services at the Santee Sioux Nation. And Jill Holt, she is the ICWA Specialist for the Ponca Tribe of Nebraska. And you can ask some of these questions to them, too, because they are going to have much better responses than I would. They're both social work professionals to the nth degree. They do a very good job for their tribes. I will just ask before we go into this question and answer session, if you do have individual cases where you are representing somebody and the Ponca tribe or the Santee Sioux tribe are involved, please dial back those questions. I know you may have individual questions to ask them, but it may not be the most appropriate forum to do so. But again, here are our panelists. And I'll ask the first question. Before we get to questions from the crowd, Jill and Misty, could you guys each talk about your backgrounds, your education, where'd you go to college, how long have you been working for the tribe, and what your job duties entail?
Okay. Like you said, my name is Misty Thomas. I'm the Director of Social Services for the Santee Sioux Nation. I've been there for a little over 9 years. I got my bachelor's and master's degree at University of Nebraska-Lincoln, and I started working with the tribe immediately after in this position. So job duties, we have our child welfare program, which includes child family services, and we have a state contract for that. And we have our ICWA program, and so then also within that we have foster home recruitment and licensing. We're the only tribe in the state that has our own licensing standards, and we license our own foster homes. We have independent living. We have a domestic violence shelter that's also under my administration. And we also have BIA Social Services, which is general assistance, and we have a Native Employment Works program. That's about it for like the services. And I have a staff of about, I think I'm up to about 10. Just hired 3 new, so and so thinking within that now we're in a big training period, so it's still really chaotic. So with a staff of 10 providing all of those services and having to know, how the state does it, what our federal requirements are, and also our own tribal code.
I'm Jill Holt. I'm the ICWA Specialist for the Ponca Tribe of Nebraska. I completed my bachelor's degree in social work from Kansas State University in 1994, and my master's degree is in social work and public administration from UNO in 2004. Of the private agencies doing therapeutic foster care work. I was the therapeutic foster care coordinator for Child Saving Institute, and I worked with Camelot Care Centers. The Ponca tribe has a lot of services, and I don't know that I could go into all of them, but we do have, if anybody's interested, some booklets up here that are programs and services guides. If you're interested in taking that. The Ponca tribe does not have a reservation in Nebraska. They have 12 counties in Nebraska that are service delivery. 2 counties in Iowa and 1 county in South Dakota. So we're spread out. We have office locations in Omaha, again, Norfolk, Niobrara, and Sioux City, Iowa. And the services provided in those locations just vary from office to office. In Omaha and in Norfolk, we have health and dental clinics, and those services are available to all natives in the area. I think what else there would be to
to say about that. As in my role as the ICWA specialist, I receive all of the ICWA inquiries and ICWA notices, and it's my responsibility to work with the Ponca Tribe's enrollment office to determine the eligibility of the children involved in the cases, and then become involved in the court cases, in all state court cases involving our kids throughout the country. So there's more to that, but you know, if you want to know more about that, if you have specific questions, let me know.
All right, I'm going to selfishly ask you guys one more question, each, and I promise I'll let the crowd go into their questions. But when one of the more contentious issues in the ICWA is tribes intervening and the decision process that tribes go through to make a decision to transfer something to tribal court. So, what is your process? What does your tribe consider when intervening in a case, and whether it's appropriate to transfer that case specifically to tribal court?
When we're thinking about intervening on a case, I guess there's different reasons why we might want to intervene on a case. One of the reasons might be the state might be going for termination of parental rights, and for us as a tribe, we don't believe in termination of parental rights. I'm not saying we don't believe in it, but we would much rather go for for permanent guardianship rather than adoption, because there's no termination of parental rights. And within our tribal belief system, we don't believe that there's anybody, I don't care how educated you are or what status you hold within a court system, there's nobody that can determine that a parent's rights need to be terminated. The only one that can determine if a parent's rights need to be terminated is the Creator. And so that's one of the main reasons why we might go for transfer jurisdiction. Because we've had cases where, there's federal guidelines that say children can only be in out-of-home placement for a maximum of, I think it's 15 or 22 months. And before we're even getting close to 15 out of 22 months, they're going for termination of parental rights. And, they've not even given the family the opportunity to get, to seek services and help themselves. And so on cases like that, we might look at transfer jurisdiction. But one of the things, unfortunately, that we would look at in those types of cases is where are the children placed at? Are they with a relative or not? Is there going to be, and unfortunately it comes down to finances, because we don't have a ton of finances. So we're going to look at, are they Title 4E eligible? Are they in a 4E eligible placement? And then also what are the parents doing to help themselves? So a lot of times, I guess what it really comes down to is finances. We try not to let that interfere too much. We go for what's in the best interest of the child, but we also have to keep that in the back of our mind if we're going to look at transferring a case. The other thing our judge likes to, like I said, where is that child placed at? We were looking at transferring a case, and it was in Hastings, Adams County. And that was one of the questions the judge asked me was, well, how are you going to monitor that case, and how are you going to provide services to that family? But if they're on reservation, especially if the children are on reservation or if the parents are on reservation and we're able to provide services, that's something that we take into consideration.
One quick follow-up, Misty. So the first time that I had heard about the sociological beliefs of tribes in this area, regarding termination of parental rights, it was explained to me as sort of like Catholic people don't believe it's possible to actually get a divorce. That's the analogy that seems to make sense in my head. Is that accurate?
Yeah, I think so.
Jill?
The Ponca tribe intervenes in almost every ICWA case that we have. There have been a few cases where it appears that the kids are going to be returned to their parents fairly quickly, where we have chosen to stay involved and monitor the situation and not intervene. But generally speaking, intervene in every case. As far as transfer jurisdiction, unfortunately, the Ponca tribe does not have as many services available for families to provide reunification efforts to them adequately. So we have not transferred very many cases. We are currently seeking some technical assistance to help us to improve our services that we can provide in order to be able to transfer cases to the tribal court. We do look at whether or not we can transfer some cases, and like Misty said, unfortunately financial reasons sometimes are the barriers for us to be able to transfer the parent's location versus the location of one of our offices, staff, time and availability, and all of the services that the family would need for those reunification efforts are things that we would look at to determine that, whether we can provide that or not.
Thank you. Good answer. All right, questions from the crowd? All right. Okay, good, good.
In the cases that you do intervene, how actively do you participate in those cases?
In the cases that you guys so repeating the question, since I missed it so much in mine, in the cases that you guys do intervene in, how often do you end up actively participating in those cases?
This is Misty from the Santee Tribe. Our caseload is not as high as some other tribes. I know that there are some tribes that have hundreds and hundreds of cases and very few workers. We're a small tribe. I have one ICWA specialist that also serves as our child welfare director, so she's a child welfare supervisor. We've been able to grow our department a little bit, so she's the supervisor over like foster care, our foster care specialist. We have a family support worker. She does independent living, but we're a small tribe, and so we don't have as many cases as other tribes do. So we like to be very actively involved. We like to we go to, as long as we can physically be there, be at every court hearing. If we can't be there, we ask to be telephonically there. We also are actively involved in family team meetings when we possibly can. If we can't physically be there, again by the phone. I prefer to be there in person if we possibly can, because I think it's a lot more. The times that I've been present on the phone, whether it's in court or, it seems like we get forgotten about if we're on the phone and we're an afterthought. And the judge is like, oh yeah, we have so and so. Do you guys have any questions? Or it always seems like we're an afterthought unless we speak up. So we like to be very actively involved, and we want to know what's going on with these families, and we want to know what services are being provided, and if we can help provide any of those services, or if we can help pay for, maybe we can help pay for things, or we might know of culturally appropriate services that are available in that area or can be provided. Like we have a Society of Care program. They do mental health, and they're more of a statewide program. It's a grant through our tribe that's expanding Native American mental health care services across, kind of across the state. I don't know if it's across the state, but they're doing telehealth. And so I was able to connect my client with a Native psychologist, and by telehealth. So doing things like that. If the state wasn't going to pay for it, we were going to pay for it. Things like that. But we like to be actively involved.
The Ponca tribe likes to be actively involved as well, and fortunately for us, we have office locations in 4 cities in Nebraska. So, and I have case managers in the Omaha, Lincoln, and Norfolk offices, as well as Sioux City, Iowa, but they also work with me very closely on ICWA cases within our service delivery area. So if I'm not able to be in person at a court hearing or at a family team meeting in those areas due to scheduling conflicts, then generally speaking, our case manager can attend as well. And I think I could just echo most of what Misty said about just trying to be at every court hearing as best we can, and offer any supports and services that the tribe can offer to the family.
Great, thank you. Other questions? I've got a whole list of them here. All right, good.
Do you guys have a program if you've got a father or a mother that aren't sure about their Indian heritage? They've heard from a great-grandma that they might have a great-great-great grandfather that was Indian, and they aren't quite sure whether that's a possibility or not. Because I've heard differing information that it's going to cost lots of money to look into something like that, as opposed to you just need to go down and talk to like the elders or something like that. Are there any programs for that?
So the question is, are there programs to determine for just the general community who are wondering if they may have some Native heritage or if they may be eligible for membership in a tribe? What programs are available in your guys' tribes to answer those questions and make that determination?
I don't know that the Ponca tribe has anything specific to assist individuals with that. Generally, if they need to be able to prove their lineage, the Ponca tribe bases their eligibility for membership on lineal descent. But when I have had questions from people about that, I direct them to, on the BIA's website, there's a guide to determining your American Indian ancestry that I think could possibly be helpful. I have not heard feedback from anyone that's used it, but it is there and it's fairly detailed. I've looked through that before. Yeah, we don't really have anything specific. If they think that they're possibly eligible for enrollment with the CITC tribe, they could possibly contact our enrollment office. There are some people within our tribe that have done a lot of research, specifically trying to research their own heritage. So I know there are some people within our tribe, but we don't have like a specific program. And I had heard too that there was some people doing some research like that with Nebraska Indian Community College, but I'm not sure exactly what they were doing.
And just out of curiosity, Misty, what is that? So Jill said Ponca tribe goes by lineal descent. What does the Santee go by?
The Santee tribe, we changed our enrollment standards. I think it was like in 2002. They changed it to be, it used to be 1/4 Santee blood. And in 2002, they changed that to 1/8 Santee blood, and they count other Sioux blood. But it's got to be Sioux blood. They don't count all tribes. And I can tell you, because one of the questions on here is that how many cases do we have, and then how many states? I can tell you that our enrollment and our ICWA cases have dropped tremendously since, in the 9 years that I've been here. We went from like 77 down to like 30. We're getting close to like where we're in the 20s. And so I was talking to my staff, what is that about? One of the main things they said was our enrollment standards, especially when we have, because all of our ICWA cases are off reservation, obviously. And so we have a lot of tribal members that are intermarrying with other races, and so really it's I guess diluting our tribal heritage blood. I could go into enrollment standards and how what do they call it? The policy of the federal government was to exterminate our Native people, and really, we see that happening. Our enrollment standards, by federal standards, is how we determine if you're Indian or not. And so it's working because we see less and less of our kids meeting those enrollment standards.
All right, questions? Other questions from the crowd?
I have one.
Robbie?
What would you say to, given all these changes,
Given all these changes or updates to the law and the BIA guidelines, and thinking about your work with kids in the child welfare system, how would you advise guardians ad litem, in light of all of this, to best protect the best interests of the Native children that they represent? What lens would you like them to look through? Because we know we have a history of a problem with Native children being disproportionately pulled from their homes and then remaining in care for disproportionately long lengths of time. What can lawyers, what can practitioners do, and how do you want them to look at these questions to get at the best interests of their clients?
I guess that's a tough question because it's tough working with GALs sometimes. be quite honest with you, it is. And I think a lot of times what people tend to forget is the cultural identity of Native youth. And I think that is one of the most important things, you know, and that's one of the main reasons why ICWA was implemented way back when, because it's impacted our cultural identity. And I can't express how important that really is. You know, it's important to everybody. It's important to every race and ethnicity. And, you know, and so it's extremely important for us as Native people. And I see that, you know, and it affects them years down the road. And so we've seen generations and generations of families coming through our programs because, and from what I can see is because a long time ago, some of them before ICWA was implemented, is that cultural identity has been damaged. And so years down the road, then they're turning to drugs and alcohol, they have mental health issues, and the system continues and continues. And it's a cycle that's really hard to break. And so I think that's one of the most important things is cultural identity.
I agree with Misty. I think too that Robbie did a good job of in his presentation talking about that following the Indian Child Welfare Act, both the state and the federal acts, is essentially in the best interest of kids. So as long as you're following that, you know that well, and you're able to really incorporate that into your work and in your consideration of what's in the best interest of an Indian child, then I think that you'll get really close to that.
And I'll just add from a dorky legal perspective, compliance with the Indian Child Welfare Act should always be in the best interest of every single child. It's been federal law since 1978. And so anybody does something contrary to the ICWA or tries to obfuscate the requirements, it's children that suffer through delayed cases, delayed permanency. So we've known this has been the law since 1978. We've had an issue following it in many cases. And so if you want quick permanency for your kids, which I think everybody wants, tribes included, following the law is the quickest way to do that. Where you start to cut corners and may not pay attention to some of the requirements, that's when your case is really going to get delayed.
I think one other thing that I would add to that too, based on some of the questions that I heard today, is that the Indian Child Welfare Act actually, after or during the course of the adoptive couple versus baby girl case, there were a lot of national organizations that came out and spoke out and said, I think there was 18 that spoke out and said that the ICWA is actually the gold standard for child welfare for all kids. So if we want to start thinking about it in that way, maybe we should consider that active efforts should be applied for all kids and that placement preferences of relatives should be in place for all kids. But yeah, that's all I wanted to say on that.
Cool. Other question? Yes.
LB 566, is that retroactive? How does that work with my ongoing implications?
Good question. I believe that LB 566 will be effective September 1st going forward. So if you had, say you had a placement decision that was made under the old statute on August 20th, you would not be able to then go back and re-challenge that provision. Or if, say you were a parent's attorney and you disagreed with the placement of the child and it was not okay under the old statute, but it is under the new statute, you could not go back and challenge that determination. I would file another motion to seek to challenge it under the new statute, September 1st going forward. Yes?
If we represent the non-tribal parents and there's a motion to intervene, I know there's been a lot of confusion as to what services, if any, that non-native parent would be entitled to if it was transferred to tribal court. Can you talk a little bit about that, of just how we can advise some of our clients of what's available or what they may or may not be able to get if it was transferred to tribal court?
That's a great question. So the question is, if you're representing a non-native parent in the state court system, and then you probably can only answer for your two tribes, but what does that person entitled to as part of the family unit. When the case gets transferred, you're the key provider of services after transfer.
So what the non-native parent is eligible for?
Yes.
I don't know that the non-native parent would be eligible. Well, the children make the family eligible. If the child, if the child is enrolled or eligible for enrollment, that would make them eligible for services. So we'd probably be able to serve them through that way. But like they probably wouldn't be eligible for like IHS healthcare or anything that would require that parent to have tribal enrollment. Like a lot of our behavioral health, mental health programs would be able to serve that parent based on the child's enrollment or eligibility for enrollment. So probably almost everything that our tribe offers, minus, they might even, I don't know, I guess that'd be up to IHS to determine their eligibility for that program as well. But
and what is IHS?
Indian Health Services.
All right. Jill?
I think that it would, the child welfare case would transfer to the tribal court, and I don't have as much experience with the transfers as Misty probably does because we haven't been transferring as many. But my understanding would be that the tribal court and our Department of Social Services would take a look at what's currently happening as far as a case plan for that family and would work starting forward from there. If there are changes that need to be made, that those changes would be made. But services would be offered towards reunification with the parents as they were in the state court case. Does that answer it, or is it still?
Yeah, I think there's just kind of the perception or question as to whether they would be eligible for any services if they were being offered on the reservation, if that's because they have no affiliation with the tribe.
That's a good question. So I guess a specific question. So if one of the barriers to permanency was, let's say the non-native parent was dependent on alcohol, would the tribe be able to offer that parent any support about, or if that was the primary barrier between reunification, could the tribe help with that issue at all?
The Ponca tribe actually doesn't have any financial resources to assist even Ponca members with obtaining the treatment that would be required. So through the Ponca tribal court, if that's part of their case plan, then it would be the parent's responsibility to figure out how to obtain that treatment and if they have a funding source that can pay for it. So it would be the same for the non-native parent in the case. If that's sort of one example that I can think of.
And I actually, that one case that I was talking about in Adams County that we were looking at transferring, that's the non-custodial parent was non-native. And we've talked to him, we've had good conversations with him on the phone. And he lives in Colorado, so probably the problem that we had was the distance. If he wanted to come back here and needed a drug and alcohol evaluation, we probably could provide that. It's probably going to cost him more to travel here than it would be to get it in Colorado. But I know that our tribal mental health and substance abuse programs, they would serve him.
Follow-up question on that. So I guess with that, when you're considering intervening and transferring a case, is that something that you would consider? Is whether they're better served in the state court system or better served in the tribal court system? Do you guys consider that at all?
Yeah, I think we had considered that, and not just for that non-custodial parent, but it was more for the family in general. What services were available for the whole family?
I have a question here.
Yes.
Is there legal counsel involved if this private case we take? I don't even know what to tell my client if the tribe's doing the case, and I had a non-tribal member, and we were sure how would he be involved? Would he have legal counsel for the tribe, or is that not part of the situation?
All right, good question. So the question is, when you do transfer a case to the Santee or the Ponca tribe, are the parents provided legal counsel and actually just kind of generally, I don't know much about it, so if you could talk a little bit about kind of how tribal court is structured, that would be, I think, really helpful.
Okay. Well, our tribal court in general is pretty small. We have one judge, and we have court every week, 1 day a week, and then we have family court 1 day a month. And we have 2 part-time prosecutors, one that primarily does criminal, and then one that primarily does like all of our family court and like juvenile proceedings. And we have one public defender, and then there's like 1 probation for adult, 1 for juvenile, a tribal the clerk, and then the tribal court administrator. So that's the extent of our court staff. And I guess if they, in times that we've had family court cases, I'm trying to remember if we've ever had any, with the ones that have had counsel, I think they paid for it on their own. But I think Brenda Kelly, the public defender, is available, and I know that they've used legal aid as well.
Jill?
The Ponca Tribal Court has a chief judge, 2 associate judges, a tribal court administrator, and a clerk of court now. That's a fairly new position. The law and order code for the Ponca Tribe is actually on their website, so that could also be a source of information to try to explain for parents. And then there's also an external tribal court manual on the website that describes the processes of the tribal court and how that works. Parents are not required to be represented by legal counsel, but they can be. I'd have to verify this, but my assumption is that it would be at their cost. However, I know Legal Aid of Nebraska does practice in our tribal court as well. And there's a list of judges that the tribal court administrator, or list of attorneys that the tribal court administrator can provide to parents that are allowed to practice in our Ponca tribal court. So. And other tribes or other attorneys, excuse me, can practice in the Ponca Tribal Court. I believe they just have to be a licensed attorney and pay a filing fee to practice.
All right. I think we're running a little bit. Actually, we're right on time, and I want to give the next group of presenters time to come and set up their stuff. So I think we're going to end the Q&A discussion. I'll be sticking around for the rest of the presentations. So if you do have individual questions about my presentation or the ICWA, on the legal side, I would be happy to answer them. On the actual doing stuff side, I think I can give you Jill and Misty's contact information and let you know how to reach out to them to ask those questions. But we just wanted to thank you again for letting us present here. We really enjoyed it. You guys have asked some really good, tough questions. And as of September 1st, we have a new ICWA statute in the state. So if you do have questions that come up, again, don't hesitate to reach out. All right, thank you.